Welcome to the latest episode of Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and today I'm delighted to be discussing recent developments in deep seabed mining before the Seabed's Dispute Chamber of the International Tribunal for the Law of the Sea and the International Seabed Authority with Dr. Aline Jaeckel and Dr. Daiana Seabra Venancio. The topic may sound obscure to those outside law of the sea circles, but it's a story of north-south conflict over development and the environment, the role of corporate actors in fragile states and ecosystems, and of 1970s sci-fi visions turned into law during an extraordinary set of treaty negotiations. And if all of that's not enough to get you interested in today's episode, we also have a pretty unique case of private commercial actors being able to sue an international organization before an international tribunal. But before we begin, our traditional first question. Alina, Daiana, what are your drinks this afternoon? Noting that it's still school hours on a Tuesday.
Hello, Douglas. Yes, because it is early afternoon, I'm having a cup of tea, just a fresh lemon myrtle tea that I've picked from the garden earlier.
Oh, fabulous. Straight from the garden. Diana?
Hi, Douglas. Hi, Aline. I'm having non-alcoholic apple cider from a French cafe here at ANU that I'm completely obsessed this winter, and it keeps myself a little bit out of caffeine.
That's a very sophisticated choice. I'm going with my standard office hours podcast recording beverage of a San Pellegrino limonata. Ooh. All right, so as new guests on the podcast, could each of you say a little about what first attracted you to the field of international law and the path that brought you to your present work on oceans governance and seabed mining?
Sure. So for me, picking international law was really a deliberate choice because it combines sort of several subjects that I was interested in when I was selecting my university degrees. So I think international law is it's a blend of, law and politics and philosophy and even a bit of psychology. Certainly in terms of, states negotiations, obviously states being represented by individuals. And so psychology is relevant to that too. In terms of seabed mining and how I got to that topic, I really have to thank my PhD supervisor for that, Emeritus Professor Rosemary Rayfuse at UNSW Law. When I started my PhD with her in 2012, I was going to look at marine environmental law and sort of high seas biodiversity, and that was, before the BB&J agreement was being formally negotiated. And she encouraged me to sort of look a little bit further because at the time, no one was really looking at the seabed. Everyone was focused on the high seas, the water column, but no one was looking at the seafloor itself. And so I spent a few weeks doing that, and I was fascinated by the ISA regime, by this attempt of, collectively managing natural resources in a way that's not been done before. And so, that got me into this topic, and I've stuck with it ever since.
Fabulous. Diana?
With me, I started my interest in international law during my undergrad, and I realized that law degree is much about property, and I was like, okay, I'm not a big fan of this, so international law is fascinating because, again, politics is quite clear in the field. So in the last semester, I had an elective course in law of the sea. And after that, I pursued my master's and I wrote about maritime piracy. And I've been stuck with law of the sea since that time. And eventually, I opened one day a call to develop a research about underwater vehicles and seabed mining. And here I am.
Fantastic.
Before to say, under the supervision of our host in this podcast today, Professor Douglas.
That's very kind, Diana. And yes, again, that was a UNSW PhD where your secondary supervisor was Natalie Klein. So Rosemary Rayfuse is also kind of part of that long tradition of law of the sea at UNSW. So Before we get to the current litigation, could one of you take us back to the origins of the deep seabed mining regime? Why did polymetallic nodules on the deep seabed floor become such a central issue in the near decade-long negotiations that eventually produced the UN Convention on the Law of the Sea?
Sure. So the discussion around seabed mining, they really started in the 1960s. So I think it was 1967 when the Maltese ambassador Arvid Pardo gave his speech at the UN General Assembly. And in that speech, he essentially alerted states to the presence of polymetallic nodules, and only nodules at the time. That was the only focus. And he had sort of very, optimistic economic predictions for those minerals. He was talking about them, generating immeasurable wealth and that they could fund development aid globally and so on. So he very much sort of focused on the benefits for developing countries. But at the time, it was unclear who would own the international seabed and so who would have rights over those minerals. And so the concern was that it would be a small group of technologically advanced states that would develop the mining tech first and then would reap all the benefits. And Ambassador Pardo wanted to avoid that. And so he suggested that the international seabed should be the common heritage and managed collectively. And that idea gained traction. The UN established a committee on the seabed and so on. And there was, at the time, there was a division, I suppose, in opinions between, whether seabed mining is a freedom of the high seas or whether it should be done as a collective endeavor under the common heritage principle. But what was interesting is that in 1969, the UN adopted a moratorium resolution, which essentially prohibited any unilateral mining pending the establishment of an international regime, which was then eventually sort of, established through the UN Convention on the Law of the Sea. So eventually this idea that the seabed, or the international seabed, is a common heritage of humankind, that was supported widely and formed the sort of basis of the UN Convention on the Law of the Sea.
Thanks, Alina. So, Daiana, as Alina's taken us through there, at the time of the UNCLOS negotiations, we have this basic political divide between developing states that are seeking redistribution of this vast potential source of hypothetical wealth on the seafloor and protection against a sort of technological land grab or a sort of new scramble for Africa, but on the seafloor. And on the other hand, developed states seeking protection and access for private mining interests. So in many ways, where that came out in the original design of the system, as I recall, was it looked a lot like kind of a planned economy model in line with the new international economic order that was being pushed at the time. So you had the ISA, the International Seabed Authority, as a centralized control mechanism. You had technology transfer requirements, complex production ceilings and quotas, and this sort of multinational public utility, the enterprise, that was meant to engage in seabed mining to generate profits that would ultimately benefit developing states. Like, I'm taking a very complex regime and squishing it right down there. But then, famously, the Law of the Sea Convention is concluded in 1982. Developing states really don't like the look, developed states with the mining technology really don't like the look of that regime. So how did the 1994 implementation agreement alter that bargain? What was the 94 agreement about?
Well, during these negotiations, the developing states were able to mobilize themselves and include in the regime their demands. For instance, they had a regime that protected land-based mining with specific limitations on quotas. They also had a promoting of transfer of technology. But as you said, the developed states were not very happy with these provisions. And they wanted themselves and their companies to that could develop the technology for extracting the minerals from the seabed to be somewhat acknowledged in the regime and protected. So close to the entry into force, the UNCLOS, it was clear that the Part 11, that is the regime for seabed, needed to be rethinked and to enable these industrialized countries to join the convention. So the negotiation for the agreement started, and it shifted the balance towards the developed states by reducing the upfront costs to operationalize this word. The ISA by adopting the evolutionary approach, also restructuring the decision-making process in the ISA to strengthen the council, and reshaping these provisions regarding the enterprise to also reduce the upfront costs for the states, and requiring that the enterprise was to be subject to the same standards that are applicable to any other contractors. So it shifted this balance. But ultimately, I consider that the UNCLOS have this very complex regime that was somewhat adapted by the agreement, but it maintains elements that are quite unique, such as the case that we are studying is a reflection of that. We have an international tribunal that is able to receive cases from private companies, and that is not something common in other arrangements in tribunals.
Right. So thank you, Daiana. So you really had this evolution then through both the original convention and the implementing agreement of this parallel system where there was meant to be both a kind of public body set up by an international organization that would conduct deep seabed mining, essentially, I'm oversimplifying, but on behalf of states that lack the technology to do it themselves, and then a parallel regime of commercial exploitation. And the 94 agreement kind of rebalances that so that there's, from the point of view of developed states with sophisticated mining actors, a more level playing field, and the potential advantages that the enterprise might have enjoyed under the model as drafted are kind of wound back. And that was sort of necessary, right? Because otherwise the developed states weren't going to sign on, and you'd have had an International Seabed Authority that lacked the technology to do international seabed mining. So, Alina, we've been talking a lot about the sort of politics of that period and how we got to the International Seabed Authority. It seems to me as a non-specialist in this area that there's now something of a reversal in the politics, and this was something Daiana first drew my attention to. That is, a number of developing states, including small island developing states that sponsor contractors, now appear comparatively supportive of moving towards exploitation conducted by these licensed private companies, while a number of developed states have called for a precautionary pause or a moratorium. Is that a fair description of where the politics is up to? And if so, what explains the change?
Yeah, I think that's a really, really good question because you're quite right. There is a significant change in positions from the 1990s. So I think the first thing to say is that the group of states that have been calling for a moratorium or a precautionary pause or anything of that sort is quite diverse. So it was spearheaded by a number of Pacific Island countries, that campaign. So it was Palau, Fiji, and Samoa, for example. They were initially sort of spearheading that campaign. And then there was a number of European countries, Latin American countries, and most recently African states that sort of joined that initiative, I suppose. So the group is quite diverse. It includes contractors, some that have exploration contracts with the ISA, and it includes some rather big economies such as, Brazil, UK, Germany, France, Canada, Chile, Congo, Kenya, New Zealand, and so on. So I think what we have now is a sort of fairly nuanced approach where there aren't clear dividing lines anymore between developing or developed countries. And the reason for why some of the states have changed their position is quite diverse as well, right? So for land-based mining countries that are developing countries, their reasons might be more economic, whereas some other countries, there might be more environmental and so on. But I think the key reasons why we have seen change overall is that just the facts have changed between the 1970s and today. So as we said earlier, UNCLOS was negotiated at a time when the assumption was that, seabed mining would create this vast amounts of wealth and profit. And that has changed completely, of course. And at the same time, in the 1970s, the environmental impacts were not really understood. And in fact, it was sort of believed that mining with minimal environmental impacts was possible because, of course, at the time, we didn't know much about the deep ocean at all. So abyssal plains for most of human existence were believed to be deserts, right?
Right, right.
Yeah, and a nice fun fact I always like about, the UNCLOS negotiations, hydrothermal vents, which are, of course, these biodiversity hotspots in the deep ocean that, scientists are studying in terms of finding out the origin of life on Earth and so on. They weren't even discovered until 1977. So UNCLOS was negotiated, so that Part 11 regime was negotiated with polymetallic nodules in mind and without humans having much of an understanding of deep ocean ecosystems. So I think if we fast forward now 40, 50 years, the situation has changed fundamentally. The economics of seabed mining are now uncertain, right? It depends on who you ask as to what the economics are. The chair of the finance committee of the ISA noted last year that when they're doing their work on benefit sharing, they're basing the work on the assumption that there would be fairly little money to be shared in the beginning. And at the same time, we now know, of course, that seabed mining would cause significant and long-term environmental impacts. I think the scientific community has been quite clear on that. So it's the change in factual circumstances that I think has sort of triggered changes in political positions among states. And different states pick different reasons here. But I think what we're seeing is sort of a genuine challenge of states trying to operate within the UNCLOS framework that was negotiated 40 to 50 years ago, but trying to implement it now in a very different factual scenario. And so that creates tension, right? We have some states that want to preserve the ambition that was, enshrined in the 1980s, this idea that mining will happen and that the enterprise will be part of it, as Daiana said, and that, there would be benefits to be shared. Then you have other countries and maybe also companies, of course, that see UNCLOS more as a vehicle to allow them to mine, but perhaps have less of a focus on benefit sharing. So it's very different to what the vision of, Ambassador Pardo was initially. And then you have countries that sort of argue that if we were to start mining now with the current technology, that the ISA wouldn't be able to meet its environmental protection mandate under UNCLOS, under Article 145. So you have all these different positions. But it's all states trying to interpret UNCLOS, in current circumstances as a sort of living document, as is often said.
Yeah. Daiana, did you want to come in on this point?
Yes, especially on the small developing island states. It's the picture is quite complicated. I don't think it's very easy to address this aspect. But we have two main groups. We have Cook Islands, Nauru, Tonga as countries that are vocal supporters of seabed mining. We have Fiji, Vanuatu, Tuvalu, and Federated States of Micronesia that are siding with the support of a moratorium for seabed mining. And this fine balance reflects their relationship with the ocean in the cultural and the spiritual levels. And at the same time, I will be simplifying here, but the ones that support seabed mining, they are under the threat of sea level rise, and we have also their main activities, tourism and fisheries, that will also be affected by sea level rise. And seabed mining presents itself as an opportunity for diversifying their economic opportunities. So this dynamics are quite complicated, and this division is clear in the small developing island states.
Thank you both. That paints a much more nuanced and complex picture of what's going on here than perhaps the one I had in mind. But Aline, I'll come to you on this question. One of the things that the International Seabed Authority was set up to do was to create rules that would allow seabed mining to proceed in some kind of orderly and regulated fashion, right? And the UN Convention on the Law of the Sea was concluded in 1982, came into force in the mid-1990s. So it's quite some way down the track. But as I understand it, the ISA does not yet have a mining code for commercial exploitation. So where does the International Seabed Authority currently stand on that long-running effort to complete the mining code? And what remains unresolved? And how close are we to the possible commencement of commercial mining in the area?
Yeah, sure. So I think the first point to make here is that with seabed mining, of course, there is at least two distinct phases, or technically three, but we can ignore prospecting for now. There are two phases that need to be fully regulated, and that's the exploration phase and then the commercial scale mining phase, the exploitation phase. The ISA has completed regulations for the exploration phase, and of course, we've had exploration contracts with the ISA that have run for quite a while. So I think the first exploration regulations were completed in, was it 2000 or 2001? So quite a while ago. So for much of the ISA's existence, the focus has been on the exploration phase because that's what was most relevant at the time. Now, of course, as you say, the ISA has been working for the last couple of years on the exploitation regulations. So in terms of how far is the ISA in its work, I think it's probably best answered by looking at the ISA's mandate that's sort of set out under UNCLOS. So one of the mandate is to ensure benefit sharing. There's been fairly little work on that so far. And one of the points to mention here is that under UNCLOS, the ISA needs to not only adopt the regulations on exploitation regulations, so on mineral exploitation, on mining, but also separate regulations on benefit sharing. Now, at the moment, there's been fairly little, I should say probably no work done in the political organ of the ISA and the council, but there has been some work done in the subsidiary organs with the finance committee. As I mentioned earlier, at the moment it's unclear, how big the benefits will be, how they'll be distributed, and also importantly, what the deductions would be. So from any benefits coming into the ISA, so money flowing into the ISA, how much would have to flow out? Because I think Daiana mentioned earlier, there is in UNCLOS this economic compensation scheme. The idea that developing countries that rely on land-based mining for their export economy, if they're negatively impacted by seabed mining, they would be compensated by the ISA. So there's really complicated issues that the ISA has yet to address. That's on benefit sharing. Then in terms of environmental protection, because that's a core mandate of the ISA, the draft exploitation regulations, I think, are reasonably solid when it comes to environmental impact assessments. So that's for the exploitation phase. The key aspect that's missing is environmental thresholds. So that would be, a ceiling, I suppose, of how much harm is a mining operator allowed to produce. So if you take noise pollution, for example, how much noise is a contractor allowed to cause and how much is too much. And of course, you need to sort of know that threshold to be able to know when does our liability apply. What point, do the liability thresholds kick in? That's unclear at the moment. The ISA is working on that, and we're sort of expecting a report on that later this year, but it's unclear whether that will have quantitative thresholds already or whether that might take a few more years. The other mandate is compliance and enforcement. The ISA has certainly been working on that, on sort of establishing a compliance and enforcement, regime. But for the time being, there is no inspectorate yet and no compliance strategy and so on. There has been discussion about setting up a compliance committee, and I think those discussions are quite advanced. So we might see a decision on that reasonably soon, but not clear yet. So the draft exploitation regulations we have, there is quite a number of points that are not agreed yet, but at the same time, the regulations are certainly progressing, and some aspects are at an advanced stage. But there is other aspects of the ISA's mandate that, haven't yet to receive much attention. So I think the ISA's task is huge. It's really complex. And I personally believe it'll take a number of years for the ISA to really address its mandate. But Daiana, do you want to add to that?
Oh, yes. Just because during my research, one thing that caught my attention, of course, it was focused on environmental impact assessments, and I looked into the current environmental impact assessment recommendations for the exploration phase, and they are quite, incomplete. So there's very little guidance on the stakeholder consultation, public participation, the procedure for feedback. And I think with the adoption of the BBNJ agreement, hopefully the ISA will also seek some coherence between the provisions in the BBNJ agreement for environmental impact assessment and what is to come in the exploitation regulations as well.
Yeah, I think that's a really good point. You're quite right that the ISA has sort of separate rules for EIAs during the exploration stage, and they are full of gaps. There's a lot that could be improved. And you're right that the BBNJ agreement obviously, raises the bar in terms of environmental impact assessments, and that's something that the ISA should be looking at and adjusting its EIA rules accordingly.
So let me just crystallize a couple of things before we move on. And I mean, I think that there's a very interesting point there about, what we expect from an environmental impact assessment process has obviously changed a lot since the 1980s. And we now increasingly see references to the obligation to conduct environmental impact assessments in a whole range of situations as being an obligation of customary international law. So the law has moved on a long way. But then you have this sort of complex question, right, of how a body set up under a treaty from the 1980s is going to adapt to standards that have been set out in the very recent BBNJ treaty dealing with biological diversity in areas beyond national jurisdiction, which is, of course, binding on an overlapping set of member states, but not directly binding on the ISA itself. So there's a hugely technically complex task to perform here. And Aline, you've given us some sense of the scope of what's got to be done, as of you, Daiana. And it's beginning to sound like an organization on the scale of, the International Maritime Organization, right, which governs dozens of treaties and has technical committees and legal committees and is, in a sense, a sort of miniature version of the United Nations, but seated on the south bank of the Thames in London. So just before we move on, just very briefly, is the International Seabed Authority, this organization that most of our listeners have probably never heard of, a vast, well-resourced, highly staffed organization with scores of international civil servants in a well-known city like, Paris, London, Rome, or New York? And how frequently does it meet? Is it permanently staffed? Are there several sessions a year with all of the member states there busily passing rules? Very briefly, what does it look like actually in practice?
Yeah, that's a very, very good point. I have to laugh because no, the ISA is not very well staffed. I haven't looked up the recent number of secretariat staff in recent years, but it used to be less than 50. I doubt it's much more than that now. So it's a small organization, and it meets twice a year. So the meeting time, total meeting time would be, about less than two months a year. And a lot of the delegates, of course, that attend the ISA session also attend, IMO, BBNJ negotiations and so on. They have plenty of portfolios. So there is sort of limited scope to really do all the tasks that the ISA actually needs to do. So for the ISA to operate as intended in the 1980s, it would need to grow substantially. And I think this comes back to the sort of different economic ideas from the 1980s, that seabed mining would become this huge industry and therefore would justify a regulator that is very well resourced and so on. Whereas what we have at the moment is different economic circumstances and therefore a skeleton ISA that is trying to meet its mandate under UNCLOS as to the best of its abilities, but is just not well resourced or doesn't have enough time to really complete all the tasks that UNCLOS has given it. So to some extent, the criticism that we see about the ISA being slow, I think it's somewhat unfair because the ISA is doing quite a lot with very little resources.
Right, and for those playing along at home, it's doing a lot with very little resources while headquartered in Jamaica, which is, I presume, a delightful place to be headquartered, but not exactly sort of Silicon Valley in terms of your access to external technical expertise. And this problem of how can the ISA function and get all of this lawmaking done brings us to the point of now the sharp contest between some of the commercial actors and the ISA itself. Lamentably, we're always short of time on this podcast, but we'll press on and try and get through as much as we can in the time available. So, Daiana, could you explain who, and I'm going to use the old pronunciation of the state, and we can come to that in a moment. Could you explain who Nauru Ocean Resources Inc., or Nori, on the one hand, and Tonga Offshore Mining Limited, or TOML, are on the other hand, and how they fit in to this system, and how and why they've now brought proceedings against the Seabed Authority at the Seabed Disputes Chamber of the International Tribunal for the Law of the Sea?
So the Nori, and I call it TOML, are private companies that are respectively responsible by Nauru, former Nauru, and Tonga. And the UNCLOS regime permits that not only states, but also private companies sponsored by states to participate and be contractors in the ISA. And it is necessary to have state sponsorship to, of course, be under the UNCLOS, which is a treaty, and also to make sure that these companies are fulfilling its obligations under the UNCLOS, under the contracts, under the ISA regulations, and also under the scope of the advisory opinion from the Seabed Dispute Chamber. The parent company of Nori and TOML is the Metals Company. It is registered in Canada, and recently the Metals Company, or TMC, created a subsidiary in the United States and applied for a unilateral mining license under the US domestic law, the Deep Sea Hard Mineral Resources Act. So to be clear, the US is assessing mining applications for areas that are not only within its national jurisdiction, but also beyond national jurisdiction in the area. And the caveat here is that recently Nauru and Tonga reviewed their sponsorship agreements with the TMC, and for Nori and TOML, and they cannot oppose any activities or pronounce themselves against any activities that happen under the US mining licensing system. With this, the caveat is also that current areas that are under the US mining leasing system overlap with the areas of TOML and Nori in the ISA, and that is in public domain. And that is the background that led to the inquiry. So although this is not under discussion in the case, it is the background that leads to the administrative procedure that is under question in now the Seabed Dispute Chamber in the ITLAS.
Right, so we've just added another layer of complexity here, which is that obviously the United States is a holdout to the seabed mining regime and has recently revived its claim to be able to independently license its corporations to engage in seabed mining beyond the limits of national jurisdiction. Okay, Aline, the applications before ITLOS frame the disputes as being about due process, transparency and fairness in an ISA inquiry into possible contractor non-compliance. So what prompted that inquiry, and what was the authority asking the contractors to explain?
Yeah, so I think as Daiana just explained, the context, of course, is sort of the risks of unilateral mining via the US at the moment. So in July last year, the ISA Council sort of initiated this inquiry into potential non-compliance by contractors. And essentially, the Secretary General of the ISA just asked contractors to explain how they are complying with their obligations under their exploration contracts. So the legal document, of course, that binds the contractors to the ISA is the exploration contract. There was two particular clauses that were of particular relevance here. The first one is that contractors have an obligation to accept control by the authority, by the Seabed Authority, over any exploration activities on the international seabed. And the second one is that not only are the contractors required to, but also all their employees, their subcontractors, and anyone working for the contractors, they must observe the applicable law, which of course is in this case UNCLOS and the ISA's mining code and so on. So the questions are whether all contractors are currently observing those obligations or whether there are any issues. That's the focus of the inquiry. Now, the ISA sort of asked the contractors to explain, as I said, how they are complying with those obligations. And the council said specifically that for the inquiry, the ISA can take into account not only the answers from the contractors, but also any information in the public domain. Because as Daiana's just said, there is a number of sort of points of evidence that are already in the public domain, and some of the NGOs have compiled some of that. So that's all sort of relevant for the inquiry. However, the inquiry has only just started in a way, so it's at a very early stage. So I think there is a bit of a question at the moment that the ISA obviously has a compliance mandate, a very broad mandate. It needs to act if there is risks of non-compliance. So it initiated that inquiry, but then the case for provisional measures was sort of filed fairly quickly. And so the ISA had to sort of pause, I suppose, or at least delay that inquiry to some extent, fairly early on in the process.
Well, and that brings us to the question of provisional measures. So, Daiana, the contractors here have sought provisional measures from the International Tribunal for the Law of the Sea, Seabed Disputes Chamber. Don't try and say that 3 times quickly. So, what were they asking the chamber to stop or protect pending a judgment on the merits, and what did the chamber decide?
Here, I think it's important to kind of summarize the main arguments on each side. So in one side, the contractors argue that their right to due process is at risk. So they ask the chamber to suspend the inquiry and essentially refrain from taking any measures to revisit this inquiry pending final decision of the Seabed Dispute Chamber. And on the other side, we have the authority that argued about 2 main things. First, that the inquiry is still in its early stages, so the request for provisional measures was premature, according to the authority, because no harm would occur unless the ISA Council decides anything about these contractors. And the second aspect that the authority also bring to the case is that the Seabed Dispute Chamber should not interfere with the authority's discretionary powers based on Article 189 of the UNCLOS. So what the tribunal had to deal with. So first, it had to answer whether it has prima facie jurisdiction, whether there is a dispute, whether the rights claimed by the contractors are plausible, and whether there is a real and imminent risk of irreparable prejudice. So the chamber recognized that has prima facie jurisdiction, saying that although the chamber cannot pronounce on the merits about the authority's discretionary powers, its jurisdiction concerns to the observance of the due process by the authority. Also, the dispute was recognized since the contractors and the authority are disagreeing to whether the due process has been observed in this inquiry. And the Seabed Dispute Chamber also considered that the rights of due process and fair treatment that the contractors are arguing are considered plausible rights to be argued in the case. And lastly, the chamber declared that the failure to afford due process may cause irreparable prejudice and can't be reversed or redressed by financial compensation. So they had to issue the order. So those are the arguments. Aline, do you have anything to add on this?
No, I think you've summarized it beautifully. I think just the sort of the key point, I suppose, was that what Nori and TOML requested was for the inquiry to be suspended and essentially for the ISA to refrain from taking any measures regarding the inquiry pending the final decision of the Seabed Disputes Chamber. But that was not, so some of that was not granted. So while provisional measures were issued, the chamber said that the inquiry can proceed. It was a sort of a fairly common scenario of everyone gets a little bit of what they're asking for, where no one clearly wins or loses the case, I suppose.
Not uncommon at all in legal proceedings, and certainly not in preliminary proceedings. So, Alina, you've just returned from a session of the ISA Council. What did the Council decide in response to the Chamber's orders and in respect of the ongoing non-compliance inquiry?
Yeah, so there's two main decisions. The first one was that the council did extend Nori's exploration contract. So the contract expired in July during the ISA session, and so Nori had applied for a 5-year extension, which is a fairly common process at the ISA. And the ISA has granted that extension. And the reason they've granted the extension was that the chamber made it quite clear, and in fact, the ISA representative before the chamber also made it clear that the contract extension and the compliance inquiry are separate processes. And so they have to be dealt with, differently or separately. Now, because that might sort of sit uneasy with the public and certainly with some states, what we've seen was a number of sort of verbal interventions from states saying that, the extension was granted, but strictly without prejudice to the outcome of the non-compliance inquiry. So there's a paragraph to that effect is included in one of the council decisions to sort of make it clear that those processes are entirely separate. And the second thing the council said is that the inquiry can continue. Right? Because as we said, the chamber did not order the inquiry to be paused. However, what the chamber did do, of course, is to affect the timing of the inquiry. So because the Legal and Technical Commission, which is the subsidiary body within the ISA that's sort of dealing with that inquiry, they only meet twice a year in March and in July. So now during the July session, they couldn't really proceed with the inquiry because they had received a letter from, the chamber to essentially pause the inquiry while the provisional measures hearings were ongoing. Once the order for provisional measures was granted, it was clear that the ISA can continue with the inquiry. But of course, by that point, the Legal and Technical Commission's meeting was over.
And the contract had been renewed. Like one might imagine if a compliance inquiry had run and completed before the contract renewal process, you might say, well, we don't want to renew a contract with these people. Would that have been a plausible outcome?
It could have been. It really depends on how the ISA applies the extension procedures. So right. The extension procedures for exploration contracts were decided back in 2015, and they are fairly narrowly construed. The ISA has normally not looked at the compliance record when deciding about an extension request. That's not to say they can't in the future, but in the past they haven't. In fact, we probably won't have time to get into it, but there was some disagreement within the Legal and Technical Commission in 2015 when they were adopting these procedures as to whether or not, compliance record should be a relevant criteria for extension. So there was a discussion about that, 10 years ago. But the ISA now didn't have to go into that because the inquiry, of course, is ongoing.
Yep.
Now, what will likely happen is that the inquiry, at the very earliest, it would conclude next year, and it might even take longer, who knows. So I suppose it sort of raises these sort of bigger questions about, how quickly can the ISA react if there is a risk of non-compliance? And, can the ISA sort of manage and govern in an efficient manner? If it only meets twice a year and if a compliance inquiry can take this long. Now, some of the delay, of course, is not the ISA's fault, but it's the proceedings now that have sort of prolonged it a little bit. So there's sort of broader questions about, compliance strategies and so on.
That is quite sobering to think about, right? That this is potentially an enormously ecologically destructive practice that could be undertaken, and the body tasked with supervising it, there are questions about how fast or how efficiently it could react in a compliance setting, particularly if corporate actors can run off to the International Tribunal for the Law of the Sea and delay everything by seeking proceedings when, again, the relevant committees of the ISA will only meet twice a year. That's not exactly like having a national level environmental protection agency that's continuously in place to do these things. We could talk about this an awful lot longer, but unfortunately time is against us. So I'm just going to move to our sort of traditional wrapping up question, which, and particularly when, we're thinking about some of the rather grim and dispiriting matters of international law at present, we always like to finish with something just a little lighter. So very briefly, what do you do to take your mind off international law, Aline and Daiana? What are you reading, listening to, watching, or doing when you need a break from it all?
Daiana, go ahead.
With me, I have a baby, so she takes me a lot out of international law, sometimes too much, because she requires a lot of attention. But also, I'm trying to read The Foundation from Isaac Asimov after watching the concert, the show on Apple TV.
Right. Absolute sci-fi classic, but that is a series of quite thick books. Alina?
Sure. Yeah. So my favourite pastime is probably bushwalking, which I do as often as I can. We're really lucky here in Wollongong, just south of Sydney. We've got very easy access to coastal walks and, the escarpment. So yeah, thankfully my entire family loves bushwalking. The kids get involved. So we do a lot of sort of bushwalks and overnight hikes and anything that gets me away from screens and computers.
Sounds fabulous. Well, thank you both for joining us on Call to the Bar. And thank you to everyone who's tuned in and listened. And you'll hear from us again very soon. Okay, bye-bye.
Bye, thank you.
Thank you.